Is anybody online? No, okay, so Mr. Smith here from Far North Willand, good afternoon. Welcome to the hearing. I think you know everybody in the scope that has been to the hearing before.
Yep.
So we've got your submission of evidence and we've read the second point jury report. So you tell us what you would like and then I might have some questions for you and then we'll go from there.
Thank you very much. Thanks, committee and members of staff. Essentially, I'll keep it really brief. There is really only just the one issue for us, and it's to do with the critical electricity lines and how it affects the innovation park, which has got a special purpose zone. So when the, just by way of background, when the park was established and we were looking at where to put buildings and platforms and things like that, all of the constraints and the factors that were within the site were taken into account in establishing those platforms. And so essentially the park itself has a 20-metre setback from the existing easements for the electricity lines which run through the park. Now, the main area is the western end of the Innovation Hub, which is where the buildings, if you've been to the Innovation Hub at the moment, there's a bunch of buildings which are occupied by Far North Holdings and educational facility providers. That's the Innovation and Enterprise Hub. That's the area that we're talking about. We're not talking about the berry farm and that other aspect, which is in the horticultural area. So the platform design and locations were carefully planned with one of the key considerations being the 110 kV line, which runs along that western boundary. As a result of a submission from Top Energy, Top Energy requested that critical electricity lines be illustrated on the plan and also a suite of rules that would be attached to those, that corridor effectively. What that has done though is that because there's no rules as such, there's only recommendations within the staff report. And so for the 20 metres that we have as a buffer between the easement and the platforms themselves, some of that area is used for core landscaping to do with the park, the overall park with its design guidelines and other matters. So there's two sets of landscaping which is effectively done. One is via the consenting process, which is more on the platform itself. And then you have some core plantings which help to assimilate the whole overall view of the park as viewed from public vantage points. The only area where the 20 metre is less is where there's a consented development for the corrections department. And in that instance, the platform is right adjacent, right up to the easement, and there is pockets which are within 10 metres there, so it's a lot closer. But that's a completed development, and there's no intent at this point to further develop that site, as far as we know from corrections.
Is that where they do the building and train the?
Yes, that's a sort of a transition location where people learn skills while they're on their last few months or years of and they're proven to be okay people, and they transition, they learn a skill, and they build houses effectively is what they're building. So within that platform, it does get closer, but again, as I said, that's sort of a unique situation in the sense it's already got consents. Half of the buildings, half of the platforms along that western boundary have existing consents in place, and the other half have not been at this point formally applied for in terms of consenting process. And as the committee may be aware, in terms of the background, we had hearing two, I think it was, where we sought to establish the special purpose zone for the Innovation and Enterprise Park, and within that there was no real questions at all from any submitters or any member of the panel, I believe, in terms of the platforms and their locations because of the measures that were taken place. The reason why we're concerned about this imposition is because for prospective people that are looking to establish on the park, they need certainty, and at the moment they have a platform which with a consent, be it a controlled, usually a controlled consent, unless they breach other rules. With a controlled consent, it's really a compliance situation, and it's a straightforward just to impose conditions that might be relevant. That side of things is certain. There's certainty for prospective people, and of course, when we're promoting the park in that sense, the rules add an unnecessary layer of additional compliance when we're already complying with the national standards for the New Zealand standards for separation distance and those sort of things. The other factor is that there's a new definition to be formalised as part of this process, and the suggestion has been to use the WDC definition. So there's some doubt and concern about what that might end up being. There's also concern from Whānau Holdings about the accuracy of where the CEL line will be illustrated on the plans, on the maps, and with defined envelopes, how that could impact on those envelopes. We've already, as I said, we've already provided a 20-metre buffer, so why do we need to have that on there as well? There's not that I could see any detail on the width of the corridor that's been proposed in terms of these measures, and there has been a suggestion within the 42A report to measure the setbacks from the centre of the line, but again, that depends on what submitters have raised and what the panel ultimately decide. So all of these offer some doubt for the potential site occupiers and for Whānau Holdings when presenting a prospectus to potential developers within the park and within the park philosophy. We had tried our best to avoid any external factors other than trying to keep people within the realms of the park's intent and the goals and the aspirations of the park, and to add this other layer of what we as Whānau Holdings consider to be unnecessary extra layer of consent or compliance requirements is a concern. And I can only reiterate that buffer area between the sites and the envelopes is targeted for core landscaping as part of the original consenting processes. So yeah, so that's essentially where it is. We acknowledge that the 110 kV lines are obviously important. We've taken measures to protect it already, and we see that this adds an unnecessary layer. It originally wasn't part of the provisions, but was added in by way of submission. So that's why we didn't have an initial submission, but we did obviously write a further submission, and this is the points we'd like to raise. So I'm happy to answer any questions. I was intending to bring copies of the setbacks to show you, but we can, if we want, do it electronically, but that's up to you.
I'm quite happy for you to do it electronically, because that's the question I've got.
Yep. Okay. Can I email you something and then?
So you can email and then circulate it, that would be ideal. That's the first question I've got. Now, just so you were aware earlier on when we were talking about this,
So what I'm emailing AK is the design guidelines, and that shows the separation distance. It also illustrates the electricity line and the easement that's on the western boundary.
So the line's currently got an easement?
Yes.
just so you're aware, this morning I did advise those people who were here and also online. As a result of the question from me, the staff have given us a letter date for 7th August 2020 three outlined why the critical line was in the district plan.
Yeah.
And also they gave us a copy of the Thornbury district plan, critical electricity line provision. And I don't know whether you want a copy, but you could probably get it out.
No, I think in the 42A report, it refers to that as a possible definition to be used.
Yeah.
And also, at the end of the day, the Far North may decide to tweak and amend it as they see fit. So, for the purposes of this exercise, for us, it's really the case that the line doesn't need to be there. If it is there, then we've got concerns about those aspects of what the definition will ultimately be, how accurate it will be illustrated on the plans, the width of the corridor, and where it's measured from. So the suggestion within the 42A report is from the centre of the line, I think, is what I read. And so those are some of the concerns that we have. It just puts in the element of doubt and uncertainty in the provisions. Did that come through?
Yeah, but it's taken a while to get across.
So you're going to get any questions in the meantime, we'll come to you, Mr. Smith.
Yeah, so, I mean, if you were looking at a provision in the district plan and excluding the particular site, a specific provision of line, you really have to have not just generic reasons, but you have to have some specific reasons why that site has some uniqueness or the like. So your reason really is the fact that you've already taken into account the line that's there at the present time, with the design elements that are. Is that the case?
That's correct. And with the uncertainty over what the eventual rules might be, it might cast an unnecessary compliance or consenting requirement on the future development of these particular lots. And so that's where the essence of the concern is. It's that doubt that provides. We want to, if a proposal, as the plan was, I think, eventually got to, as a result of the hearings, where we got to with the consented, with the agreed terms, was that proposition within those platforms would trigger controlled application to council, and it would be really along the lines of a compliance, making sure that matters were dealt with. We don't want any doubt, because then it's difficult. We can't say for sure that it's going to be approved. And obviously, if you go beyond the controlled allowances, then obviously that's for you to argue and justify. But I mean, for the purposes of putting out, this is what you can do, and there's no problems. We just have to do the landscape and do the parking, do the whatever else is needed, the signage, the colour scheme, the building design has to be a certain design as well, all of these factors. So all of these platforms were done, and we honestly thought that 20-metre buffer would have been sufficient to avoid any possible risk or contention with that. And it's quite a substantial strip, because you've got the easement already, which is a variable width along that boundary, and then you've got 20 metres as well, except for that correction site, which is already pretty much completed and done.
So,
You got it?
Yeah, so there are other sites in the Far North that are adding with that specific.
It depends probably on whether they've got an area where you're allowed to build, and that's your envelope. I would suggest that there may be some sites. I don't know whether, but you've also got to have the 110 kV line running through there, of course, as well. So and there's an existing easement. So and so from that side of things, now if you I just needed to go down to any of the maps.
You can actually press that little clicker and point it over towards my computer. Can you see them?
You're over here.
That'll be.
Is it going?
Yeah.
Just
Oh yeah. Oh. Can we blow up the image?
We can go through this and
You can. So all I was going to show was, if you look in the.
you come up and point there. You come up and
Was
point.
this point or not? No. Okay. So what we're talking about is this. We're talking about this line, so the 110 kV line runs along this boundary here, and the easement is the hashed area that's illustrated there. And you'll see that the light green gap is 20 metres.
So how does it get out of the area?
Pardon?
Does it stop in the middle? No, we just said it runs a flat boundary.
Oh, it runs all the way up here
To where?
and up there.
Ah, okay.
Yeah.
So there's nothing, why isn't there nothing on the top end? Easement or whatever.
Oh, that's just probably, I'm not sure whether there's easements further on or not.
Ah, okay.
But we're focused on this piece here. So the Top Energy don't have easements over all the lines that run through the park. And I definitely know it runs up to here. So this is the correction site here that we were talking about. And so it drops up to it goes right up to the easement boundary there, but the buildings are still at least 10 metres away from the actual easement. And most of this is just hard stand that's used for storing materials or temporary occupation by completed structure.
If the line, like normally you say the lines continue on at the top.
Yep. Goes up through here, I think.
Well, we probably need to know whether there's an easement there or not, because we've got to make a decision, and if we decide, well, you've already got an easement, there's no point in putting this on, because you're a unique case, but you've got that bit there that's.
Yeah, I'd have to check on that. I think the focus for us was about where the platforms are, so this plan here is really about platforms.
I understand that, but we've got to look at the bigger
Yeah,
picture.
absolutely.
Well, if you decide that you have that bit for the north,
Yeah.
there's no easement there, will you voluntarily put one on, the same as what you.
I would say there'd be no issue in putting one over, yeah.
Do you want to have a think about and speak to the farmer Holland and just say, you can send some evidence in?
We can confirm that, yes.
This easement, at this stage, it finishes there. If the commissioners staff want to consider the matter, you might have to have an easement extend to the boundary, or you're not, and then we can use that to make our decision.
I think on the district plan maps, it runs through there and goes over this way on the angle.
I was just saying, well,
The pink bits here, lilac,
yeah,
they're where the buildings are going to go. So there's nothing proposed. And in this area here, it's all it's not really suitable for anything. Really.
but again,
Yeah.
other people can have the same argument, well, we're not going to put any buildings there.
Yeah.
Or you're a bit different to other.
Well, anything outside the pink, these lilac areas would be non-compliant. So the rules are not tailored to that, and there's no intention. There might be some agricultural activity happen in those spaces, but that would be it.
I'm just saying, like, on pine tree, which then will go through the line. I'm just saying, if there's no easement there restriction.
Yeah.
Which is what Top Energy want. I'm not saying they're going to get it, but that's what they're after. If you voluntarily put a 20 metre thing, if that's what you accept in evidence.
Yeah.
Let us know.
Okay. Yep.
Just,
Honestly,
when after the, whatever the act is, the approach, how long is things around the place? What's the corridor width and setback set out in the act? You know? I thought it was very specific.
It's very specific. It depends on the voltage of the electricity lines and the spanning. So it typically ranges from 5 metres to 15 metres.
15 or 50?
15.
15.
Yeah. So I guess that's an important point, is that what the electricity line rules are doing is essentially triggering compliance with the NZDCP. So it's really just trying to reinforce those. And if you already comply with those, which it sounds like this development has been designed to do, there shouldn't be an issue.
Yes, so you've got the easement line plus 20 metres already.
Yeah.
And then tree plant, I mean, I know there's lines, tree plants all over the place, and you can't do a lot of activity under those lines, even growing maize in some areas, because the company has to have access approximately. So I'd be interested in your comments around what are the main concerns when you've already looked after or considered corridor width and setback under your existing resource consent building concepts.
It's really just that because those rules haven't been finalised in terms of provision, and so we're only relying on Mr. Waith's report in terms of his recommendations in that sense. And so from that perspective, there is some, we just want to reiterate our situation. our preference as always was to remove it, and that was clear within our submission. And the 42A report didn't really delve into where it should go or where it shouldn't go. It was more focused on what the provisions could be and things like that. So in that sense, that's why we're keen to reiterate our argument, and that the special purpose zone was actually one of the added zones to the provisions, not one of the through the submission process, rather than in the original set.
If you provide a copy of that plan and also some evidence from Far North Lowland about the bit that missing at the top.
Yep.
Whether they will or will not accept voluntary easement, which is what you've already got,
Yeah.
then send that in to AK and she can circulate that the office technique consider that before you do right to comply.
That's fine. We can sort that out this week.
Okay, anything else you want to?
No, it just sounds like what you've said outlined that I've already considered the safe distances. It should in theory already comply with the rule.
Just that last bit that if we say right we've complied, but then something happens that last bit, everybody can then they're going to face if we decide to accept one top energy accept. So you've only got 110 kV lines, not no 33s?
I don't believe there's any through there. No.
Okay.
Well, certainly the only critical line is that
That's on there.
just along that western boundary. No, that's the only one close to any buildings that we could have or do have.
Just given the Act actually allows a whole lot of things to happen with these lines, if anything was done here, if it mirrored what the Act, the specifics of the Act, would you be happy with that?
I think more than likely, because that's we're already allowing for it. But the issue we have is that because there's uncertainty over the width, all those factors which I mentioned before, because they haven't been finalised and they're still subject to confirmation from the panel. That's what the concern is, and it would bring in probably an RDA consent of some sort needed. And we just don't want to be having a potential consenting issue. We just want to be able to say, yes, go for it.
I think we understand. I think Mr. Waite picked up what you said, and if you could provide that information,
Yes.
we can consider it further.
No problem.
Right.
Thanks, mate.
That's all right.
Thank you very much. Right,
Told you it'd be short.
I think the moment might be open if you can come the other way.
Yeah, I came up through the middle because it wasn't open until I think on the radio I heard it was open when I was about 2/3 of the way up. So yeah.
Still at Harrow Falls.
Yeah. Just out of white here there.
If you have an adjournment, or
Yes, so next time is Fiona, so she could be here and she's doing keys. Yes. I think she's here.
okay, we'll have an adjournment.
She's here.
Right, what do you want? You're
It's all,
oh, they're all one.
yes, Fiona is representing.
Thanks, guys.
I might be mistaken about that. I might be. I've been mistaken about that.
Yeah.
Oh, you're with Fiona, right?
Yeah.
But she's not here. Okay. Cool. Well, maybe we will adjourn, Bill, and then,
Okay, that's all adjournment.
okay.